All right, so welcome to it. This is going to be your first of many online lectures for law studies, and all you guys have to do is sit there, enjoy it, listen to what I have to say, and that's it. I'm not asking for much. Hopefully you'll enjoy this and learn something, but above all, I hope that everyone is staying home, staying safe, avoiding the coronavirus, and making it through this pandemic with your friends and family and everyone safe and healthy. So let's pick up where we left off. Where we left off before this whole thing started was with the First Amendment. And we talked about freedom of expression and speech. And we said that freedom of expression includes a lot more than just the things that you say. It includes a symbolic speech, like, for example, burning a flag, raising a middle finger, things where you have a message and that message is understood by the audience. Not necessarily the audience agrees with it, but that message is understood by the audience. Those things are considered symbolic speech, and they're protected under the First Amendment of the Constitution. But we started to discuss special areas where the First Amendment might not apply as it does in other areas. And for you guys, for all of my students in law studies, one of the most important places where we can discuss how the First Amendment applies is in public schools. And in the textbook that I have for you, it discusses the First Amendment in public schools by talking about perhaps the most important case dealing with students' freedom of expression, freedom of speech. And that is Tinker versus Des Moines School District, and it happened in 1969. And we actually discussed this a few times in class, but we were actually going to get to this right before everything shut down. So in this case, it's presented like this. Mary Beth Tinker and her brother John were opposed to the Vietnam War. Remember, this is the late 60s. They decided to wear black armbands to school as symbols of their objection. So just picture it. There weren't school uniforms at this school. They were in regular street clothes, I guess jeans, t-shirts, whatever the case may be. But they also wore these black armbands in an effort to protest the Vietnam War. When school administrators learned of this, they adopted a policy of asking anyone wearing armbands to remove them. Students who refused would be suspended until they returned to school without the armband. So they said, no armbands, take it off or you're suspended. When you decide to take it off, you can come back to school. The Tinkers and 3 other students wore black armbands to school. Although some students debated the Vietnam issue in the halls, no violence occurred. So there wasn't this huge disruption to the academic or learning environment, right? The 5 protesting students were suspended from school until they came back without their armbands. The students sued the school in federal court, arguing that their First Amendment rights had been violated. So here's what I want you to think before we even get into the case itself. Did these students have a First Amendment right to express themselves by wearing these black armbands in school? Did the school have a right to tell them to take it off? What arguments can you make for and against? What arguments would you make as the student? If you were Mary Beth Tinker or John Tinker and you were being suspended, what arguments would you make to say that I should be allowed to wear this armband? Okay? What argument would you make if you were the principal? If you were the principal for discipline, what argument would you make to say that these kids should not be allowed to wear these armbands and that we are allowed to take them off or allowed to tell these kids to take them off? Should wearing armbands be considered protected speech, right? A symbolic speech, expression. If you were the court, how would you decide this case? Would you side with the Tinkers? Would you side with the school? And remember, as students, of course, by default, you want to side with the kids. You want to side with the students. You want to be like, I'm allowed to express myself, right? But think realistically for a second that if you were the school, understanding that what would have to be done in order to educate all of these students? Can we allow freedom of expression to disrupt the learning environment, to disrupt the academic day? These are things that you would have to figure out if you were the administrator. So ponder all that. If you were the court, if you were a Supreme Court justice, how would you decide? All right, think about that before we go any further. Pause the video, do whatever you want. I'd offer to get up here and tap dance for you, but I figured that'd just be a waste of time. So now let's discuss. So in Tinker versus Des Moines, the Supreme Court decided that the right to freedom of expression does not end at the schoolhouse gate. Meaning the Supreme Court acknowledges that you as students do have freedom of expression. You do have the right to express yourself. You do have the right to voice your opinions, even on school premises. Your freedom of expression doesn't end simply because you walked onto that campus. The court held that wearing armbands was a form of symbolic speech protected by the First Amendment. Remember, symbolic speech or expression doesn't have to be verbal. It's something where there is a message, and that message is understood by an audience. Their message was, we're protesting the Vietnam War, and everybody knew that those black armbands represented their disdain or their objection to the Vietnam War. So it is symbolic speech. And the Supreme Court said that their right to do it is protected under the First Amendment, even in school. Now, before the decision in Tinker, the Supreme Court had never recognized a student's First Amendment right to freedom of expression in a public high school. Right, so this was huge. Before this, they never recognized that this was a legitimate right that students have. After Tinker in 1969, the Supreme Court said that yes, symbolic speech, freedom of expression, is a protected right that students have. However, the court, and this is the big part for you guys, also held the student's right to free speech could be restricted when the school could show that the student's conduct would, quote, materially and substantially disrupt the educational process or interfere with the rights of other students. Okay? So if your freedom of expression would substantially interfere or disrupt the learning environment, the right of other students to learn, or interfere with the rights of another student, then the school can limit your freedom of expression. Okay? Such a disruption did not occur in reaction to the Tinker's armbands, nor could it reasonably have been predicted. And there's that word you guys hate so much. Reasonably, right? We talk about the reasonable person standard in things like torts. This is going to keep coming back over and over and over again through all of the cases we're going to study for the rest of the year. If it could have been reasonably foreseen that them wearing black armbands would have materially and substantially disrupted the educational process of the rights of another student, the school could have preemptively told them, hey, you can't do this. And if you do, you're going to be suspended. But again, here, do we really think that that was reasonably foreseeable? Probably not. Because as you read in the case of the student armbands, when I read you the little synopsis of it before, it clearly said that they only were having discussions in the hallways. Right? That was it. So their suspensions were declared unconstitutional by the Supreme Court. So here's what you guys have to know. You have to know that your freedom of expression does not end when you come to school. Symbolic speech, nonverbal speech, where you have a message and that message is understood by an audience, is protected by the First Amendment and has been acknowledged as protected by the Supreme Court. However, if your symbolic speech would interfere with the educational process, or it could reasonably have been foreseen that it would interfere with the educational process, then the school can limit your freedom of expression. So what does that mean? Political pin? Trump 2020, Biden 2020, G 2020, you know, you could vote for me. It's possible. I mean, I could be president. Would that reasonably interfere with the educational process or other students' rights? Probably not. What about a Make America Great Again hat? Haven't we seen that has caused some division in schools, even between students and teachers and things like that? And remember, I give you no opinions of my own. I'm just asking you to think about this. It's possible. So could a school tell you you can't wear it? If it would cause enough of a disruption to interfere with the learning process, it's possible, right? There's the Nazi Party of America. That's apparently a legitimate political party. Could you wear a Nazi Party swastika hat to school? Probably not, because that might... people might have a problem with that, and that might actually cause some, interference in the educational process. But think about that. So that's where the line is drawn. And again, this line is something that the administrators have to look at and sometimes make the call on the fly based on people's reactions to what your symbolic speech in the school is. All right, so think about that. That's the lesson for today, Tinker versus Des Moines, and your right to symbolic speech in school. Leave some comments. What do you think, right? What might constitute something that might disrupt the educational process, the learning environment, or the rights of another student? What should be banned at school? What do you think people should just maybe get over and allow students to wear or express themselves symbolically? All right, and also, as we continue with this, if you have any other questions on things we discussed before, maybe other things you'd like to see, put it in the comments below too, because we're going to go on in the next couple of lectures that I do. Next, we're going to do the Establishment Clause and the Free Exercise Clause of the First Amendment, which is freedom of religion. And we're also going to apply that to what students can and can't do in schools and what the Supreme Court has said about that. So, yeah, just let me know what you want to discuss. And if there's a question of legal importance or something that's been bugging you, or about this lesson or future lessons or past lessons, let me know. And I'll be happy to make video lectures based on what you guys want to discuss constitutionally, legally, all those sorts of things. So again, remember, this is all I'm doing. My number one concern is that you guys are healthy, you're safe, you're home, and you're taking care of yourselves. This is probably going to get a lot worse before it gets better. And ideally, when this is all over, I'd like to see you all back again, happy, healthy, and doing the best you can do. All right? So until next time, be good.